I would point out as Judge Wilson's counsel, no relation, however, this would be my direct examination. I will apologize to the panel members in advance because this has been more of like an appellate argument than a true trial with the judges asking questions, much like I often do in appellate arguments. My outline already has large scratches through it, so I'm going to bounce around to try not to be repetitive on matters that have already been covered by the justices thus far.
Please proceed, sir.
Thank you. Your Honor, Judge Wilson, I want to start by going to Respondent's Exhibit 1. And let me okay, and let me get Exhibit 1 up. The pretrial order in the Lang case. I'm going to move to page 2. And here in this area, can you tell me what that is?
Apparently that is the defendant's signature, Ms. Lang.
And beneath it, what about this area here?
That apparently that is Mr. Michael Pham, her defense lawyer's signature.
Okay, so both, as I understand it, this pretrial order would have been provided to and signed by both the defendant and her attorney?
That's correct.
So any deadlines in there would have been apparent to them when they signed it?
That's correct.
Okay. Now let's move forward to, and I want to ask you a few questions to fill in some gaps on the motion for community supervision, Exhibit 4. Mr. Robertson had pointed out to you a code of criminal procedure about motions like this. The deadline to file them was before the trial. Were you presented with this motion before the trial began?
No.
What was the first time you saw this motion that is dated down here, August 14th, 2019, and file stamped August 14th, 2019?
After jury trial began.
Was it after the jury had been picked?
I believe so. The transcript will show that. I believe so.
No. If we are to operate under the code of criminal procedure and the deadline Mr. Robertson gave us, would this motion for community supervision have been timely under the deadline he's stated from the code of criminal procedure?
No.
Was it timely under the pretrial order that was entered in the Lang case?
No.
Okay, Your Honor, I want to, one other document here. Get this back up. All right, Exhibit 5, Respondent's Exhibit 5. Can you tell everyone what this is?
That's the election of punishment. Ms. Lang and her lawyer, Mr. Pham, are electing the jury to, in the event of a guilty verdict, to conduct the punishment phase.
And what is the plea that Ms. Lang entered in this written filing?
Not guilty.
And if you could, the file stamp, what's the date?
August 14th, 2019.
The date of trial?
Yes.
So, Your Honor, when the Lang case was called to trial, what was your understanding of Ms. Lang's plea?
Not guilty.
Now, as we've touched on previously, I would say more than touched on it, you've gotten a lot of questions about it. Mr. Pham doesn't ask any questions to the jury. Did that concern you?
Absolutely. That's a huge indicator of ineffectiveness.
And why is it that you saw that to be an indicator of ineffectiveness, Your Honor?
Because the jury trial had begun and the jury only would conduct the punishment in this case.
Okay, but if we're getting beyond guilt and innocence, why is it that an effective counsel wouldn't at least, why is it that an effective counsel would at least ask some questions of the jury?
If the defense strategy was to plead guilty, a defense lawyer would conduct the jury panel questioning regarding punishment. If normally defense lawyers will conduct jury questioning on guilt, and if they have selected the jury to conduct punishment, they'll ask questions regarding punishment.
Is it possible that without the state's consent, you could have taken over and assessed the punishment at this point in the trial?
The answer is no.
Now, after the jury's been picked, and it's on page 44 of the transcript, and if everyone will humor me, I want to go ahead and use the transcript as a guidepost from day one of the trial. It is Respondent's Exhibit 6. All right, now here, beginning at line 6, Mr. Pham tells you that his client, Ms. Lang, wanted to plead guilty, correct?
Yes.
So why is it that you told Mr. Pham at this point, no, we're going to keep going?
That was after Mr. Pham had failed to ask any questions of the jury panel.
All right, no, we see on page 45, and as it has been touched on, Ms. Lang enters her guilty plea. You then have the lunch recess here on page 46. No, after the lunch recess, we see here in the transcript, Mr. Justice says, Your Honor, we just need some clarification. Am I reading that correctly on lines 21 and 22?
That's correct.
No, when Mr. Justice and the attorneys approached the bench, you asked them for some authority as far as how to proceed. Were they ever able to give you any authority showing that you were required to accept the guilty plea?
No.
And while this is going on, meaning the lawyers conferring, on page 48 of Exhibit 6, and I'm not going to put it back up, but Mr. Pham presents you with the motion for community supervision. When he did that on page 48, after the jury had already been picked, was that the first time you were presented with a motion for community supervision in this case?
Yes.
And a page later in the transcript, you asked Mr. Pham whether or not Ms. Lang was pleading guilty based on his advice. And can you recall what the transcript reflects on that?
Basically, Mr. Pham answers yes.
Let's go ahead and show this just to be clear. And right here, what I'm talking about, page 51, line 8. But that's what Mr. Pham's, that's what you instructed your client to do. Isn't that right? And what's Mr. Pham's response there on line 13?
Yes, Your Honor, I'm her legal counsel.
So I'd like to ask you a question at this point, Your Honor, because you're not going to get into attorney-client communications between Mr. Pham and his client about the reasoning for that and what he told her, what his explanations were. Hypothetically, if Mr. Pham had instructed his client, if you plead guilty, I can get you community supervision or probation, and she had elected to plead guilty based upon that advice, would that have been erroneous?
Yes.
Objection.
Go on.
Calls for speculation.
Response, Mr. Wilson?
Well, the response, Your Honor, is this is a board certified criminal lawyer and the judge who was presiding over the trial. So his knowledge about whether or not advice like that would be correct or erroneous goes to his background, Your Honor.
You're speculating that the advice was given with regard to community supervision or that was the basis of her decision to plead guilty. We don't have any evidence of that, do we?
We do not, Your Honor. So let me re-ask that hypothetically.
Rephrase your question, please.
Yeah. Hypothetically, Your Honor, if a lawyer instructs a client, if you plead guilty, I can get you community supervision in your court, and they have not presented a motion for community supervision to you before a jury is picked, would that advice be erroneous?
Yes.
Why?
Because the defendant would be ineligible for community supervision, and then the plea would not be voluntary.
He's ineligible for, they're ineligible, that you cannot grant community supervision on your own as in your discretion as the judge?
Well, again, Justice Williams, the Tharp case controls this situation, THARP.
Yeah.
That is, the citation is 393 Southwest 3rd 751, Texas Court of Criminal Appeals, 2012. That case stands for the proposition that when a jury trial begins, if a defendant attempts to plead guilty, then the defendant may plead guilty, but the jury will conduct the punishment phase. In general, that's called the unitary trial doctrine.
Okay, but you can't, regardless of what the jury does, you can't then, I thought we went through this before. You can then, in your discretion, grant community supervision, correct?
Yes.
Okay, thanks.
But
go ahead. There was a but there. Did you want to add something else?
Just to repeat that the jury was to conduct the punishment phase in this case, according to the Tharp case, THARP.
So let me ask you, Judge Wilson. We have a selection by the, for the jury to conduct a punishment phase in this case, right?
That's correct, Justice Alvarez.
Can you nonetheless, despite that, set aside what the jury decides and give community supervision?
There again, we've talked about code provisions, but according to the Tharp case, THARP, I don't believe I could do that.
Okay. Thank you.
Thank you, Judge Alvarez.
You may proceed, Mr. Wilson.
Thank you, Your Honor.
But in the end, nobody wanted community supervision, right?
That's a problem.
I'm sorry, Justice Williams.
In the end, nobody wanted community supervision, right?
I can't say nobody wanted. I don't know what was in Ms. Lang's head. What was her expectation?
Okay.
Well, to go ahead and finish up with this, at the hearing after the trial, what did Ms. Lang tell you regarding the verdict that was handed down?
She was happy with it. She was satisfied with it. Did not want a lawyer to be appointed for it.
Okay. No, Your Honor, there's been a lot of discussion about this as well, but here I'm sharing again Respondent's Exhibit 6, which is the transcript from day one of the trial, and the cross-examination by Mr. Pham of the arresting officer. If I'm seeing this correctly, it starts on line 11 of page 66 and ends on line 23 of page 66, correct?
Yes.
What else should he have asked the arresting officer?
Well, he could have filed a motion to suppress at the get-go of the case. That's what's normally done in the DWI case, to challenge the stop, to challenge the contact by police officers. So what could have been asked at that point? It could have conducted cross-examination, could have conducted regarding the defendant not being able to perform the field sobriety test. So
Judge Wilson, what do you know about the defendant's contract with her lawyer? What do you know about their fee agreement?
Nothing.
Do you know whether he had agreed to charge some kind of a lesser fee because they agreed not to challenge the arrest or the stop?
No, I do not.
Thank you.
May I proceed?
Please.
All right, no,
You may, I was muted.
oh, I'm sorry, Your Honor. I took liberties and assumed the case was yes when no one interrupted or told me no or asked another question. No, in the transcript, and I'm not going to bring it up, Your Honor, but when it reaches the point of the state calling their next witness, the blood draw nurse, can you remember whether or not she was available?
She was not available that day.
And at that point, what did Mr. Pham do with regard to the toxicology report?
He stipulated to the introduction of that evidence.
No, in your experience, and let's go ahead and take it forward to now, as
Is that on, is there any, anything in the record about that? I don't see anything in the record about
I'm sorry, Your Honor, let me share the screen and I will show you in the record. I was trying to speed things up and stop bouncing back and forth.
Sorry.
No, let's get it right.
It starts
on-
at the bottom of 67.
Thank you, Your Honor. Yes, right here, Mr. Justice, line 20 of page 67. The next witness would be the blood draw, Your Honor, blood draw nurse, that's all. But above that, Mr. Justice says on line 11, that's where he identifies who the witness is. Your Honor, my next witness won't be available until tomorrow. I'm sorry. I hadn't expected this case to go longer than this witness. Right there?
Mhm.
Okay, so Your Honor, my question to you is, in your experience with DWI cases being tried in Harris County, both as a lawyer beforehand and as a judge, have you come across jurors that, or have you observed jurors that will not convict a DWI defendant without the toxicology report?
Yes. They will not convict.
Did this circumstance where Mr. Pham stipulated to the admissibility of the toxicology report, did that affect your view on his effectiveness as Ms. Lang's defense attorney?
Yes, normally there is cross-examination of the blood draw nurse, what steps were taken, whether the location was clean, sanitary, especially the chain of evidence once the blood draw is complete.
Now, do you know if Mr. Pham had already stipulated to that with the district attorney?
Previous to the stipulation on the transcript, I do not know that, Justice Williams.
Okay, what does he say on 67? Doesn't he say we've already stipulated to that, or what exactly does Mr. Pham say on page 67 about the stipulation? Yes, if you could pull it up, please.
Right here on lines 23, correct me if I'm Mr. Pham, I think we already stipulated to the toxicology.
Okay.
The court, well, I don't tell lawyers how to present their case, so.
So do you know at what point, whether it was before that was announced that the toxicology person was not available that day? Do you know if in advance of that he had stipulated with the district attorney's office to the toxicology?
Justice Williams, I don't know the answer to that.
Okay, that's what I needed to know.
Now, skipping forward to day 2 of the trial, Your Honor, and this is something that the examiner and the commissioner's office has been focusing on.
Mm-hmm.
It's Respondents Exhibit 7. Right here, beginning on line 11 of page 4, Ms. Lang is present. Lawyers, what I intend to do is appoint a lawyer after the verdict on punishment to represent Ms. Lang on the motion for new trial. Did I read your words correctly so
That's
far?
correct.
And then you asked Ms. Lang, do you object, Ms. Lang, correct?
That's correct.
And what was her response?
No.
No. By this point, the jury is deliberating punishment.
I don't recall, Mr. Wilson, whatever the transcript shows, the jury deliberated twice, once for guilt, innocence, once for punishment.
Okay. And can you recall whether or not you stated your intentions in the middle of the trial while the jury was deliberating on guilt and innocence, or towards the end when they were deliberating on punishment?
I'd be guessing, Mr. Wilson, but I suppose that was when they were deliberating punishment.
All right. And you touched upon this earlier, but just to be clear, at this point, you had determined that Mr. Pham had been ineffective as Ms. Lang's defense counsel.
Yes.
And by this point in the trial, because you've talked about the voir dire several times, at this point at the trial, if you could, please tell the court everything that you had seen to lead you to what I consider to be this important decision on your part that led you to share your intentions with the defendant and the attorneys.
Well, again, it was the more than one instance of Mr. Michael Pham's ineffectiveness. The major item of ineffectiveness would be his not questioning, not conducting voir dire of the jury panel. If his theory was punishment, he could have asked questions of the jury panel regarding punishment only. Again, the motion for community supervision was not timely filed. Very importantly, the Tharp case controls who would do the punishing. Only the jury was to conduct punishment. When a jury is in panel, the state does not waive a jury trial. Only the jury can conduct punishment. And again, Mr. Pham had not conducted any questions of the jury panel. Additionally, Mr. Pham had very little questions of the cross-examination of the arresting officer. Normally, in a DWI case, defense lawyers file a motion to suppress, and there is substantial questioning. Sometimes it takes an hour, 2 hours, sometimes 3 or 4 hours of questioning regarding the motion to suppress, question whether the police even had a reason to approach a defendant. And normally what defense lawyers do, they ask for this motion to suppress, and if the motion to suppress is successful, then no evidence can be introduced regarding the arrest, regarding any field sobriety test, any breath or blood test, or any conduct by the defendant.
Thank you, Your Honor. No, moving forward.
Excuse me, Mr.
Yes.
Wilson. Additionally, at opening statement, Mr. Pham asked the jury to find his defendant guilty, and he conceded that she was intoxicated.
If the toxicology had not been stipulated to, and if counsel for the state had said, we have this witness to testify on toxicology, she's not available today, but she's available tomorrow, would you have considered a motion for continuance?
The short answer, I would have allowed the witness to testify, but the harm in this situation is that Mr. Pham did not conduct any cross-examination.
Are we at breaking point, Mr. Wilson?
Your Honor, if we can take about 5 to 10 more minutes, I
That's
think
fine. That's fine.
we can be done and reach a more clear breaking point.
Okay.
The truth is, as a lawyer, I'm at a breaking point whenever the court tells me, so,
No, you got 2 hours, so I want to give you all the opportunity.
okay. Nope.
I'm just seeing a lot of hungry faces, that's fine.
Okay, well, hopefully they can focus for just a few more minutes. Because what I want to touch on, Your Honor, is at the post-trial hearing after the jury rendered their verdict. And I'm sharing what's from Respondent's Exhibit 8. And let me scroll forward to page 7 or page 6, where we have the hearing on whether or not to appoint new counsel. When Mr. Pham asked Ms. Lang whether or not she still wanted you to appoint new counsel, what was her answer at the post-trial hearing?
She responds, at this time, no.
And then you asked her for an explanation, correct?
Yes, I asked her on the record earlier, you indicated yes. Is that correct? The defendant replies, before the verdict was reached, it was a possibility of yes. And the court, I respond, okay.
So at this point, once Ms. Lang has made it clear to you, and reading from line 7, I am happy with the results and I do not want to change counsel. Did you still appoint new counsel for her?
No,
Did you respect her wishes at that point
yes,
after she had provided you with this explanation?
yes.
No, Your Honor, I'm sorry, Your Honor, your honors that are hearing the case, at this point, I think it would be a good break for lunch. Like I said, there are a few more questions, but I am shifting gears.
Okay, it's 11:21. Let's be back here at, I'm just giving you a half an hour. So in a half an hour and 30 minutes.